Hi, everyone. Welcome to our new podcast on LawWiser. The topic for today's podcast is around the new labor codes that has just come up in November, and where we will be talking around if these codes are reforming the workplaces or creating new compliance risks for the company. Recently, India has consolidated 29 fragmented statutes into comprehensive four labor codes, and it got implemented on 21st of November. And they are aimed at simplifying the regulation, promoting uniformity, and expanding protections to the employers. So for this, we have Mr. Satyajit Gupta. He's Vice President and Head of Legal at EXL, and Ms. Gurmeet Bindra. She's partner at KBD Partners. We welcome both of you on our podcast. So, yeah. So the first question is to Gurmeet. From your perspective, do the labor codes genuinely reduce regulatory burden, or do they shift compliance from law heavy to interpretation heavy for the companies?
So my view is that I don't think the burden has reduced, only it has changed the form. Though I appreciate and understand that the legislature, they intended to reduce the regulatory work. And for this reason, the various statutes, they have been consolidated. There is a common authority. They have digitization that has been done. And also the common registration is there. But the difficulty which, our clients are facing is that, there is a lot of interpretation work has also come up. Like, I mean, and also the clients are anxious, once the different states are going to notify these the provisions as well as the rules, how it is going to fit into their structure of work and environment and the employment environment. So that is, so my take is, yes, the intentions were right, and there are some good changes are also there, but I'm afraid that it's not really reduced the burden. That's my take.
Sure, sure. I was also speaking to somebody, and they were talking to me about that they are still waiting for the state regulations and things to come in to understand the codes better. Um,
So there's
on
a lot
that,
of uncertainty regarding that.
yes, a lot of uncertainty right now. Satyajit, coming to you now, how should companies operating pan-India navigate conflicting state-level implementations under the same codes?
Sure. Thanks for the question. And of course, I think first off, thank you so much for having me on the LawWiser podcast once again. I think this is a fantastic topic, and I think all of us are dealing with, these codes. The code's about 4 5 years old, but implementation wise, I think since 21st November, I think it's been keeping many of us awake. So I think when you look at it, I absolutely sort of echo what Gurmeet mentioned. Labor codes I feel are sort of a conglomeration. It's sort of consolidation of all these laws, but like the labor laws earlier, right? There was obviously certain items which were with the state, certain items with the center. There were different sets of regulators and all of that. So I think that issue, somewhere still remains. The hangover of the earlier frameworks is still there. While the labor codes are national, but in terms of execution, it's still there's a federal structure to that. The real compliance unit for me still remains the state for many industries, for many, especially in the services sector. Uh, we are typically taking the approach that look, let the code be a sort of unifying, like a floor, if you would call it, and not the ceiling, right? So we are sort of saying that, okay, let this be the common minimum program, and then we are looking at, okay, if in a particular state there is any variation because the Shops and Establishment Act laws, etc., still around. Practically, what that means for us is that we are sort of trying to do a state deviation tracker, looking at what are the deviations in different states. We are trying to look at modular policies with which are allowing us to build sort of those deviations for particular states, and also encouraging actually for this particular law we have said, look, legal will not drive it. It has to be HR and our HR statutory compliance teams. They need to build the knowledge and they need to build the local exposure to try and see whether the local implementation is very clear. The biggest shift for me is more in the governance. It's not law. We need to all build an infrastructure for dynamic compliance, right? Not we can't sort of rely on those old books and manuals anymore. We'll have to basically recast all our frameworks. So I think lots of work to be done, and for companies operating pan India, a lot of we need to rely a lot on external counsel, external practitioners like Gurmeet. So it's great to be here, and we look forward to your insights.
Yeah, sure, Satyajit. But as you said, a lot of things is going on. How is compliance strategy around it is happening in the companies post codes, or has risk management become more ambiguous post the codes have come into the picture?
Right, right. So thanks, Avni, again. I think, look, like while of course the consolidation has helped, right? Obviously, instead of having 29 or 30 different laws, we are looking at four. But operationally, we are, as I think, we've been discussing, we are still in a transitional stage, right? Lots of uh, uncertainty. Some of the old laws are still around. The new codes have come. The rules are still in draft form. FAQs are still coming. I think on 13 March, 16 March, also some FAQs have come. We all know that FAQs sometimes can be more confusing. So actually, I would say in terms of risk, it's not reduced yet. It has just changed shape. While there is less risk of outdated compliance because we know the law, probably it's a little better, and we've all become experts or whatever, or we've all done a bit of study. But there's more, I think, a risk of interpretive gaps and inconsistent enforcement as of now. And of course, we all know that while all these laws came on 21st November, I think, immediately if you ask, there's been no real, government's also allowing people to settle in. But at some stage, just building, I think right now it's time to build that structure to manage that risk and, formulate that compliance strategy because very soon, we will have to go into audits, we'll have to get into probably, large scale, inspections, etc., where all these new structures will get tested. And I would say right now what we are also doing is in certain areas where there's some confusion, we're sitting with our advisors and trying to see how can we take take a sort of thoughtful approach where we're able to document and see how we can make ourselves more, inspection ready, audit ready.
So, while the companies are working on their strategy, uh, Gurmeet, you were just speaking about how the advisory work has increased in the law firms as well. So, are you seeing increased advisory work because companies are now unsure, like how to interpret the codes properly?
Yes, absolutely. The now our clients are approaching us, because their HR policies, they are revising their HR policy. They're asking us to look into it again and see that they are in align with the labor laws and especially the wages structure. And as Satyajit also saying, and as I said, that interpretation because they have changed certain, to make it more. I think they try to maintain a balance that it is friendly. At some provisions are friendly with the labor, some are with the management. So as a result of which, there are a lot of definitions have changed. Like for example, the wages. Now they have divided into two components. Like they have said, okay, the first component is the basic salary, then your dearance allowance and your retention allowance, and thereafter the other allowances are in the other category which are not the part of the wage. But the basic cannot be cannot be less than the 50% of the CTC. Now what they have done is in the definition they are saying, okay, these are not included in the basics wage or salary, and they have given that, okay, certain allowance, like they said that conveyance allowance, they've named certain allowances that they are excluded from the wage definition. Now what the our clients are facing are, suppose they're having they were giving an allowance to their employees, but that allowance is not in the excluded list. So therefore, they are having these issues now. If they are not in the excluded list, so whether they would become a part of the basic wage, or you can still navigate it as an excluded. Like suppose you are giving a recreational allowance, which is not there. Now will that, because it is not there and the company are giving that, So how that will be treated eventually. So these are the gray areas, whereas earlier, with the Supreme Court judgment became whatever is fixed will fall under the wages and what is not will only be the allowances. So with this bifurcation, and although as a lawyer, I will say, okay, it is this list is not exhaustive, but today the companies they are because it's a wage structure. Okay, so they have a lot of budget is made on basis on that. So they don't want to take any chances. They want to be very sure so that tomorrow somebody should not come back and say that this will fall, because even the contribution and all will be based on that. So those are the things which the our clients are struggling with. So we are helping them how to have the wage structure so that you play safe. And also, like, gratuity, for example, as you must be aware, I think it was there all in the newspaper that fixed term contract, even if terminated for whatever reasons, the gratuity is payable now for every year. But then there is a situation, suppose there's a prospective quotes. This is my understanding. They are not saying it is retrospective. Now, if the employment was already hired, like employee was hired before 21st November 2025, and it is terminating after that. Now, how the gratuity is to be calculated, I mean, whether that this is law will be applicable. So those are the various issues for which, regularly we are getting a lot of queries from our clients. Like annual pay, see, you must be aware of it, like, this annual pay, annual leave, you were allowed the encashment in the end. Now they're saying every year you can. So those are various issues the companies are struggling with how to budget their finances. So those things have come.
Thank you so much, Gurmeet. That give us a very practical insights as to what companies are facing problems with. Coming to my next question for Satyajit, is decriminalization of offenses under this codes a real relief, or does it mask deeper regulatory scrutiny?
Sure, so that's a great question once again. Look, decriminalization per se is very welcome. And I think that's also, it's not only happened in labor codes, but overall, I think across all commercial and civil sort of matters, a lot of decriminalization has happened over the last few years. The point obviously is that, okay, it's intended to reduce criminal exposure for procedural lapses, which earlier was a real pain point, especially keeping in mind that the people on the hook were the officers in default, the senior, officers, directors, etc. I don't see it necessarily as a deregulation because, look, inspectors, or I think now they're called inspectors and facilitators, nowadays have been given higher, authority to impose higher penalties. The compounding powers have also been, given. And as you are all aware, different regulatory agencies now share a lot of data. There's because of the digitization, there's more data visibility out there. The scrutiny or regulation is not reduced. It's just become more structured and evidence driven. The real relief, I feel, is for companies with strong systems and for companies which may not have invested or are not still working on strengthening their controls. The risks will continue to be there and may be higher. It may not be, sort of criminal penalties they may be, getting exposed to, but, in terms of the fines, in terms of the other penalties that they may have to pay, that may eventually be higher, and which also, these are also a cost of, which contributes, ultimately in terms of increases the cost of doing business in the country.
Sure. Thank you. Gurmeet, before this question, you shared a lot of interpretational related gaps which the companies are facing. So, do you anticipate any surge in litigation in the initial years while the codes are being implemented due to these gaps which companies are facing?
Yes, absolutely. See, I think this is very inevitable whenever the reforms come, whenever the old laws are reformed and new laws come. So this is the very inevitable situation because, see, earlier there are many areas of the law which have already been decided by the court. So authorities were also following that, whatever the interpretation the Supreme Court has or the higher authorities are given. Now with this change in the code, there's a change in the definition. So enforcement authorities, as per, will always give a very strict and narrow interpretation to those definitions. So unless and until then again it will land up in the courts, for the court to give it a right interpretation. Probably they will try to also sink in. And especially this because it is prospective and law, and there are certain old, like still transition is happening. So this overlapping of the old laws and the new laws, this is a very tricky situation right now. Most of the companies are facing. I wish they had made it a little more, brought a little more clarity to this overlapping transition concept. Maybe it will come in the rules. I'm not sure. Maybe they at some notification will come, because currently, because of this, doubt and gray area that most of the companies, they do not know. They do not know today, like, tomorrow if the state is going to bring the rules, what are they going to say? uh, and how different states are going to have different rules. And if one state is saying, okay, I'm agreeable with one aspect of the provision, the other state says, no, I'm going to further add to it or reduce to certain provisions or benefits which are there for the employees. So that is going to really create a lot of litigation. Which happens with whenever the reforms come. So I won't be surprised if it happens.
Yeah, sure. Coming to my last question, and it is to both of you. Unlike jurisdictions like United Kingdom, where enforcement is relatively centralized, or the US, where fragmentation is expected but stable, do India's labor codes risk creating a uniquely unpredictable compliance environment due to evolving state rules and limited enforcement clarity? You both talked about it, but if you can give us more clarity on this.
So my understanding is that it is always as because we are dealing with clients which are coming from different states. Sometimes they're having a pan-India offices, like Satyajit said, like their companies having a different. So what it really is, a unified court is always better, because then I know that for I have to have one. Suppose there's a leave, like suppose in some states, the leave is that regional leaves are also given, and some states are not given. So those are the issues which they feel that I mean, then head office is open, but the branch off because they have to work. So the branch office is closed because of the local festivals or local holidays are there. So those but we are living in a country. It is challenging at the same time. I understand it is not possible also, but at least if for the major thing, because the idea was to make it simpler for the companies. So apart from certain areas, but if the every state is going to come with their own notifications and with their own different dates of notifications and different rules. So as compared to any country, be it UK and I mean the USA also have different states, but I think they do have unified. In a way, it's all unified. So I would say that way, a unified laws would have been much welcome.
Yeah.
Yeah, sure. So I think Gurmeet makes a good point, and I think there was an opportunity to standardize and consolidate even further. Um, I don't think. I mean, many of these laws came because sometimes with the change of regime, there was an intention to show that okay, there's some progress which is being made. The law was passed 5 years back because of various reasons, strategic reasons, it was held back. And now also in implementation, I think it's sort of, and Gurmeet made a great point that look, they could have, I mean, they've had so much time, they could have prepared a rollout schedule, they could have done
Yes.
that, okay, look, around the world, there are various, laws which have significant import typically come, and are rolled out in stages and, so that things are clear. And I think the points she made about, frankly, if let's say certain, certain provisions are applicable now, obviously they're applicable from 21st November, but they also impact transactions which we would have started doing prior to 21st November. So, in those cases, let's say if you're telling industry employers that okay, you need to pay gratuity to people who are, I think the fixed term contracts point that Gurmeet brought up, uh, that has not been costed in, right? So that means employers basically have to spend from their own pocket and sort of pay for that. And we can't gratuity is an amount which can't be deducted from the salary. It has to go over and above. So I think while and also while there was a lot of initially when it was launched, there was a lot of discussion that, okay, hey, it's being brought for the employers and also employees. It is supposed to give employees a lot in terms of, more social security, etc. But when we analyzed it, we actually saw that actually there was more cost which goes on to the employers. Employees really don't get much more. There's more money which goes into social security, like the provident fund, etc., the government trusts, etc., which, frankly, while they have become much more, the provident fund department, of course, over the last 10 years has become tremendously, easier to deal with, but still, obviously, not as easy. But it's not that it's delivering even higher, sort of take homes for the employees. Uh, so I think there was a lot of opportunity to do more,
Yes.
but of course, being maybe if you're pragmatic, then we can say that okay, let us see how this benefits us. Maybe through industry body representations, etc. We can request government to sort of clarify. And then, obviously, I think to the point you made, the question around the entire thing about fragmentation, etc. Those are difficult to comment upon. UK is a very, very small, sort of, it's probably the size of an Indian state. US is larger, federal fragmentation there, but of course now with how things are there, nobody knows what's going to happen. We are fortunately, unfortunately, we are here in India. We have to deal with it, and I think obviously while there's a lot more to be done, but I think clearly there is a change. We need to deal with it and I guess make the most of it. While I think there are a lot of great things about the code, but I think definitely uh, on the other hand, there is a lot more to be done, right? So we are at a very early phase right now. We have to work together with whether it's employers, whether it's advisors, whether it's the government bodies, etc., to deliver ultimately the intention of and the promise of giving a more, reasonable, fair position to the workforce. I think that was my thought process.
Thank you. Thank you,
You
both of
can.
you.
Thank you. Thanks, Avni.
Both
Thank
of
you
you.
so
I
much.
think it gave us a very balanced perspective from the company side, from the law firm side, also the interpretation and challenges related to it. So thank you so much again for your insights, both of you.